Strike all that.
Paragraph 14, last sentence. The sentence beginning the necessity for completing the election.
Yes.
Before the expiration, the term is enjoined by the Constitution, public and state interest, and to see that the governance of the country is not paralyzed by non-compliance with the provision that there shall be a President of India. Next paragraph. The impossibility of the completion of the election to fill the vacancy in the office of the President before the expiration of the term to office in the case of so-and-so, as may appear from Section 7 of the 1952 Act, does not rob Article 62(1) of its mandatory character. The maxim of law in potentiae excusa legem is intimately connected with another maxim of law, lex non cogita impossibilia. Impotentiae excusa legem is that when there is a necessity or invincible disability to perform the mandatory part of the law that impotentiae excuses. The law does not compel one to do that which one cannot possibly perform. So I cannot possibly resurrect the Constituent Assembly and say, I want your opinion on this matter. So therefore, when it appears that the performance of the formalities prescribed by a statute has been rendered impossible by circumstances over which the persons interested has no control, like the act of God, circumstance will be taken as a valid excuse, so and so, etc. So it has two aspects. One, you are relieved from performance. You are also relieved from performance in the way it commands you to perform.
Yes.
29. Paragraph 21. An argument that it shall not be done is available in paragraph 21. Portion of paragraph 21. The interveners submitted that the units of the Electoral College were House of Parliament and the Legislative Assembly of the states. Johnson submitted that the democratic character of the Constitution demanded that there should be elected members of the Legislative Assembly of the states to be entitled to cast votes at election. It was said that states were denied the right, they would be denied representation. It also said that if the states were denied the right to cast votes at election, the parity between the states and the union would be disturbed. All that argument is considered, and kindly turn to paragraph 29. Again. It was said by the interveners that Article 54 reflects the democratic patterns of participation by the states in the choice of the president, and if a state were denied such a right, it would be undemocratic. Recourse was taken to Article 368 to show that Articles 54 and 55 are mentioned in the proviso of Article 368. And if any amendment of Articles 54 and 55 is required, consent of the states is necessary. It therefore said by the intervener in Articles 54 and 55, read with 368, would be a key to the interpretation of Article 62 that no election of the president could be held without the representation of the elected members of the Legislative Assembly of the state where the Assembly has been dissolved. These submissions on behalf of the intervener are without substance. Then we go to paragraph 47, the conclusion. Can you also make a note of paragraph 33? If as a result of resolution of a legislative assembly of a state, there are no elected members of a legislative assembly of a state will not have an elected member of the state legislative assembly to qualify for the electoral college. It may be said in the analogy of the observations in the Karake Supra, there are vacancies in the electoral college by reason of the fact that there are no elected members of the legislative assembly of the state where the legislative assembly is dissolved. That matter will not be a ground either for preventing the holding of the election on the expiry of the term of the president or suggesting the election to fill the vacancy caused by the expiry of the term of the office of the president could be held only after the election of the legislative assembly of the state where the legislative assembly is held. So for the proposition, and then kindly paragraph 47, the conclusion is drawn. Paragraph 47 is the page 57, landing page 57 of the judgment.
Yes. Yes, Mr. Attorney General, we've seen that.
Therefore, we are trying to find out if falling back on the proviso is an impediment. Therefore, the president is deprived of the authority under clause 3 to go either way. Will that not do violence to the text and the intent of Article 370? So one principle in law is very clear that no text once enacted will efface itself out. We only know the principle of express or implied repeal. So there's nothing like I have done my duty, therefore I exit the scene. Clause 3 still remains as an important part of reaching the exit stage. The only question is, how do you reach it? What is the more fairer way of reaching that exit stage? What consideration will weigh the president in exercising the power under clause 3? One possibility is, maybe it's extreme, to say that because the Constituent Assembly is no longer exists, the proviso dissolves itself along with the Assembly. That's one way of looking at it. Suppose we don't want to go that route. Then the president could have said, I am free to exercise my power under clause 3 to bring to a close all of Article 370, subject to whatever other considerations the president may take into account. The other way is, should I try to follow a precedent set by the president earlier by recourse to Article 367 and recourse to Article 371D? So, extending any provision of the Constitution with modification and find out if I can possibly take the assistance of any body who can fit in within the framework of the Constituent Assembly. So in 2 occasions, the president has done that earlier. I'll come to those details. There are a large number of provisions in the Constitution, which Dhawan also tried to point out, non-legislative functions of the legislature. You pass a resolution, you pass recommendations. These are non-legislative functions. Recommendation power, a role assigned to the Constituent Assembly, was a non-legislative function. It is not a legislative function at all. The reference. Medium page. And then we have a key in Article 356, 1B, where after a presidential proclamation, the President can declare that the powers of the legislature. It doesn't say the legislative function. He talks about a compendium of powers available to the legislature, and that the President takes over to be handed over to the Parliament. For the sequence of events which is contemplated in a situation like this, where there is a void, there is an impossibility of complying with the proviso to clause 3. And how do I fill that void, if at all it's a void? I said the President could have said, without recourse to any other course of action, I could have myself taken decision on rendering Article 370 inoperative subject to modifications. But the President does not adopt that course. She wants to be guided by a process which will closely be approximating to the non-legislative functions of a constituent assembly. That is where the legislative assembly substitution comes in. And once it is the non-legislative power of the legislative assembly, under 356 1B, the Parliament can certainly say, I take stock of what I can do. And the Parliament recommends to the President, which then we see at CO 273. So therefore, there is a sequence in which President addresses, having regard to the magnitude of the problem, the importance of the solution to be arrived at, and the difficulties in handling these momentous issues facing the nation and J&K for a long period. So all these imponderables enter into the decision-making process by the President. Therefore, if a particular process is sought to be the best process, in order that any legal objection could be taken against that, is not taken. You will still find a hole in that. That's a different matter. That's how the sequence of events have taken place. So I don't find that, for if the doctrine of impossibility stars one on the face, you are not paralyzed. So clause, since Article 370, the author, sometimes I wonder poor Gopalasammy Iyengar, we keep talking about his statements in the Constituent Assembly. He had traveled far beyond what he thought was happening. Therefore, if we think that clause 3 of Article 370 was undergoing a natural death, I don't find any room for that to happen at all. So what happens today is, because of the age of the text, the long duration by which Article 370 has been used, rightly or wrongly, we have counsel for the petition saying we are reasonable authors of the text of Article 370. On the one hand, the original author, the original intent, and its practice over a period of time, which can be given a certain understanding and construction. On the other side, we are the reasonable authors of what we'll say about Article 370. Well, two schools of thought there. One which says 2 and 3 will efface itself out. The other says the whole of Article 370 will go, because after 1957, it can't serve any purpose. So this conundrum of two reasonable authors entering into a construction as against the intent of Article 370 and its practice to be considered on an objective basis, having regard to the purpose which Article 370 was sought to be invoked at that point of time. So all that will enter into the construction of Article 370. So that's why I say the president is not precluded from taking stock of all this. He's not really writing on a clean slate now. I mean, one has to take stock of what has happened over a period of time. You may have so many choices of action. You may have called upon to comply with certain mandatory requirements under the Constitution. You may have taken Article 3 review of the legislature. Very important mandatory requirements in ordinary times. But when certain other compelling circumstances which confronted the nation for a long period, the parliament, the president. So therefore, all those variables which enter into taking a final view on Article 370 has been taken in this manner. That's why I started saying about Lincoln, I quote from an entirely different perspective. It's not about end justifying the means. It's about taking stock of a very complex situation. Do we have a mathematical formula to do it? Or do you only measure it by saying there are constitutional mandates? If you disobey them, you breach them, then you can't follow any portion as regards Article 370? Or look at the future of J&K? I do not know whether these questions can be answered on any normative mathematical position through a judicial scrutiny and then weighed on very fine golden scales. Very difficult. So when Keshavaranda Bharti has told us now, look here, don't breach fundamental features of the Constitution. Now it's become an integral part of our understanding of the Constitution. Therefore, we are told to go forward, say how. The salient features of the Constitution and its functioning and exercise do not permit any deviations. Fair enough. But you look at the entire Part 18 of the Constitution, 352 onwards. And 352 occupies a very important place in the constellation of Part 18. External aggression, internal disturbance. So how do we have a mathematical yardstick and a criteria to say, this is how you will do it in the context of external aggression. This is how you will do it in the context of internal disturbance. You will have some fair, broad standards where fundamental values are not breached. But if there is something which you have to negotiate, even with the breach of some fundamental values, what do you do? Is it a political question or is it a pure judicial question to be answered in the basis of textual reading of the Constitution? That's what is confronting the court. But we are trying to assist the court in saying that you come as close as possible certain meanings which will advance the course of justice and understanding the scheme of Article 370. This maxim, impotentia excusa legum, has been applied in a large number of circumstances in the field of contracts, in the field of legislations, so on and so forth. I'll give a few illustrations later after I then may take your lordships to go beyond this judgment. Take me to submission. P70. A few minutes. We have a mass of
What else? What more now, Mr. Attorney?
I may request Lordships to come to my written submissions and that's volume 4. Just want to place a few comments at this point of time.
What would be the PDF page?
Yeah. Volume 4. There's a separate volume.
Yes.
What page? You were
Yes,
read up to the
page,
point. So
PDF page 26. Couple of paragraphs from the submissions. I just want to make a small
page 26.
observation that in the context of what I was trying to communicate to the court, one looks at all those statements from Keshavananda onwards, Bommai in the 1977 resolution case, the justiciability of the decision-making process. President or no president does not make a difference. If the justiciability will enter in the decision-making process. They were all cases of dissolutions of assemblies. A very narrow question of a dissolution of an assembly. But we are went in a larger canvas. Lordship, please.
You're referring to the standstill agreement or something? So that is what page 26 is about.
Which is the para that you're referring to, Mr. Attorney?
Yes.
Because page 26, we have, the standstill agreement, as Justice calls it.
Yeah, page 26. I think it should be page 27. It begins at page 27. Video page 27.
Idea of Article 370, its relevance and scope.
That's right, that's right.
Let's read through it. Let's see. Yes, we
Video
got
page
it.
27. So before I try to convey this, that you try to invoke the jurisprudence of Bommai in a context like this, that could be a problem. As I said, there is a context of a resolution of an assembly. What factors go into it, whether they are relevant, objectively scrutinizable or not. But we are, as I said, in a larger canvas of taking a decision which has not only an importance for the purpose of looking at a part of the constitution to serve a certain purpose over a period of time, but looking at the future. So in all those cases, you're looking at an event which had a limited impact at a given point of time. We are looking at events which will have far-reaching importance forever in the future. And for anything which is said in Bommai as conclusive in regard to judicial review, sovereignty, etc., I think may not be opposite. Let me not be taken to be understood that merely because there is too many complexities involved, the importance of the decision to be taken, and the impossibility dimension, etc., certain fundamental mandatory requirements of the Constitution can be slighted. I'm not proposing that at all. But we are trying to find out if, without slighting them, if there is a way that has been adopted, or if it's not been fundamentally breached, irreversibly breached. I'll come to that argument a little later. Therefore, the court will look at it very differently. So let me try to read a few paragraphs of my submissions here in 370. I have been trying to say this, that in paragraph 3, Article 370 envisaged a scheme of constitutional integration of the state of J&K with the Union of India, and thereby establish an interim system for the governance and administration of the state of J&K unit. A complete integration was achieved as was done in respect of other states. That's why much labor was taken by learned solicitor to tell your lordships. Look at the long history of what happened in the rest of the country. We all went through, many of them went through the process of constitutional ideas, constituent assemblies, a draft constitution, then comes Beer Drafts Committee on a model constitution. So all that has been gone through in the rest of the country. So it is nothing new which has happened here. Only thing is, having regard to the situation obtaining then, the external issues. The Parliament thought, let us tide over it. How do you tide over it? We need a mechanism to tide over it. And we also probably inject into it a constitutional integration thought. That constitutional integration thought as the three aspects of 370, as I told you last yesterday, that I have set out in paragraph in the running sequence under the same page 30, paragraph 9, the three dimensions of Article 370. So except the third dimension, namely termination, the other two dimensions have deep relevance to the constitution making process, constitutional integration process. So how will Parliament come and legislate before the Constituent Assembly takes a final call on what kind of a constitution we will have or a document we will have? So it enabled Parliament to come in and legislate during that period. And once that is done, which has now become a permanent feature of the Constitution. So constitution making process was there. We have in Article 371 and 2 subclause B. So the other part is you extend the provisions of the Constitution. That's an equally important part of constitution making process. So once you extend the provisions of the Constitution, then what remains thereafter? So final constitutional understanding of what framework a Constituent Assembly will arrive at has to be aided and assisted by this process. Importantly, a fair element was drawn in, consultation and concurrence. We're not at the point whether it's Sadri Riyazat, a governor, later prime minister, all those things are probably irrelevant. You're looking at the substance, not the form. If these are the three dimensions of Article 370, I would very respectfully say the termination of the role of Article 370, it could have happened any time. It could have happened soon after 1957. It could have happened even after when the Article 35 was introduced and somebody could challenge this, what is happening in Article 370? Now that it has happened at some point of time, the termination has to be brought about in a particular way, which is the best and the most suitable way the president thought in the given circumstances. That's why I said taking stock to be an effective way of bringing it to a closure. I can't imagine anything out of thin air. I have to find out the best way available within the framework of the Constitution and the precedents available to the President, where Article 371D have been invoked, substitutions have been made. That's why I'm on pains to point out that when you talk of substitution of a Constituent Assembly by Legislative Assembly, we are looking at the non-legislative functions of the legislature as well as the Constituent Assembly. If the Constituent Assembly had recommended to the President before 1957, it would have done the same job. So if it could be done by any other equally competent body, now today first steps in the Legislative Assembly, and because there is a President rule, the Parliament steps in. To say that the Parliament is of a lesser paramount character than the Constituent Assembly in taking decisions for the nation's future. So therefore, there is a weighing or a balancing may have to be a very, very difficult job. But my submission is, so the termination of Article 370 must occur at some time, notwithstanding whatever has happened over a period. And if the termination can occur in more than one way, whichever is the way which will advance the larger interests. That's why you look at the firmament of Chapter 18, Part 18 of the Constitution. I yesterday read out few parts of Chevrolo judgment to show that the president, the exercise of power of the president is legislative and not executive. The governor's powers under the 5th schedule, powers under the 6th schedule to extend a parliamentary law to the 5th schedule area has been said to be a legislative exercise. So modification has been considered with several judgments to say it's a very wide amplitude. It's as good as sitting in judgment over the parliamentary legislation or the constitution. President is given that power to extend the constitutional provision with modifications, with that supreme authority given to the president. Yesterday I pointed out at page, PDF page 33, as part of Chevrolo's judgment. The middle of that paragraph, where it says, Your Lordships have that page of my. One sentence, application conforms to this. That's right. That's right. I just want to. Then let me take Your Lordships to few aspects of the recommendation. It's only to throw some light on that. Paragraph 12 at page 36. You can pick up any dictionary or any precedent on this question of nature of recommendation. There are a larger number of provisions in the Constitution of India which uses the word expression recommendation. The context would be important. Sometimes it's a recommendation which can't be simply ignored or disregarded. Sometimes it can be binding. But by and large, the recommendation concept is to advise, to commend for action. All that few illustrations I have set out here in paragraph 12, I don't trouble Your Lordships with reading. I just only conclude this part of the argument by inviting a lot of attention to paragraph 18 of the submission, that page, internal page 38. Neither the legislature of the state nor any resident of the state has any independent right in the continued retention of Article 370. In other words, beyond the constitutional integration process visualized to be completed, there was no other purpose of Article 370. As such, no person could claim the right of permanent retention of Article 370 as a permanent integration process. And the concluding observations are in paragraph 21, begins at page 39 and ends at page 40. And the last few sentences here, running to this page number 40 of the PDF. And that's right.
Let's read your conclusion, Mr.
That's
Atkinson, how you sort of sum it up.
Therefore, we are told that Article 370, by reason of its exercise over a period of time, is now open to several interpretations. And there's only one solitary interpretation, that it is to aid the constitutional integration process. Whatever has happened even thereafter will have to be seen in the light of that. If anything has, by way of deviation occurred, well, it is open to correction by the president. So that's precisely what's happened now. The president says, I started saying, the president is not precluded from taking stock. The taking stock is inherent in Article 370. So if there is anything intrinsically which forbids the president to take stock of Article 370 and its exercise over a period of time, then one can understand it. But I don't think anything is available there. So therefore, I think it will open to the president to take stock of all the exercise undertaken under Article 370 and take into account the larger considerations which loom large before the nation, particularly the state of the case.
Yes, Mr. Anything else, Mr. Attorney? Now?
Your Worship. So we are confronted with just shifted the page. This part of it. Page. Sorry, navigating the system.
We are also navigating the time constraints, Mr. Attorney, now. So I think we can wrap up now, Mr. Attorney. If something remains, you can tell us after lunch if there's some thought which escaped your mind or something.
I would have done it very briefly now.
Yes.
Right. I had a. Shared with the court. There's some document I wanted to share with the court. I think it's missed getting into the court system.
Mr. Attorney, why don't we do this? We'll call upon the next counsel. You can come back to us after lunch if you're junior and you can
I
fund it
do
at lunch. We'll give you 2 minutes.
I-
There's no difficulty. So if there's some important thought that you have missed, we'll certainly not stand on the formality of concluded the argument. We'll let you again. So if there's something which remains, you can tell us in a minute after lunch, Mr. Attorney General.
Very well.
Thank you, Mr. Attorney. Mr. Sarve will be arguing
Yes.
after this. Yes,
I
Mr.
have-
Sarve.
Short submission, ma'am.
To make, before I come back on that. In my prepared. I thought we wanted to share a 2-page note with your lordship, but I think it didn't get into the system. Let me do it.
There's some thought which remains. You can come back after lunch. No
Very
difficulty.
well.
Thank you, Mr. Attorney General.
Very well.
Thank you. Yes, Mr. Sarve.
Yes.
I have a few, okay, then I'll come back after.
Yes,
after
certainly.
lunch.
There's something, a point here or there which has been missed out. You can
Yes,
tell us.
I'll
We'll add
continue
it.
that up.
We'll add it.
Because there are a few observations I want to make on certain aspects. So can I continue thereafter? Yes.
Yes. Yes, Mr. Sarve.
Yes. My lord, I don't want, your lordship has heard this matter on both sides at considerable length. And the solicitor has, in great detail and with his customary meticulousness, ticked all the boxes and covered all the points from our point of view.
Appearing for in this matter, for the sake of the record, we must make a.
Yes,
note of
ma'am. I'm appearing on behalf of the applicant in IA 9573 of 2020 in petition 1099 of 2019. I have, my lord, for your lordship's convenience, made a 3-page roadmap of what I'm going to submit, if your lordships permit me to hand it over, so that it will be easier just instead of your lordship noting down.
Yes, Mr. Sarve.
Yes.
Has it been given to the court master already?
I believe so, my lord. Mr. Agarwal from. It has been sent, I believe.
अभी भेजने यार। We'll just display it for everybody because that way the other side also knows what your arguments
Yes,
are. To be. So therefore we take it as just an aid memo, nothing more.
It's like a skeleton of submission.
All right.
It's just It just sets out the points which I'm going to address, not what I'm going to say.
Just give us a moment, it will be uploaded so that
Yeah,
that way
not sure.
your learned friends on the other side also simultaneously
course.
can see what we have. Shankar Narayan, you can tell Mr. Dhawan and Mr. Jha. They'll get it on the main screen as well. But I'm sure the main screen will also have it for. Edward.
No, without interrupting my learned friend, I just want to, there's some part which is missing in our, I try to upload it I can share with the lordships. Right.
Yes, Mr. Sarvesh?
Yes. But I'm only to, as my note said, I'm only supplementing some of the submissions which have been made already. And I've just picked up the issue. One is the construction of the proviso to sub-article 3 of 370. The attorney has addressed your lordship at length. Only a few points to add to what he has said. The width of power under Article 370, because that has been the subject matter of some discussion. The nature of the power exercised by President under various sub-articles of Article 370, I don't think, there was a suggestion made that this might be executive in nature. The absence of a challenge on administrative law principle of abuse of power. It's necessary to get a few concepts in their right perspective. The exclusion of judicial review beyond the question of competence, questions that are political in nature. And the use of power under 356 to make changes that may be irreversible. And finally, the violation of basic structure. Very short submission in each of these headings. The first point, my lord, relates to the construction of the proviso. Your lordship, I've heard detailed submissions by the solicitor and by the attorney. And my lord, I just want to put it in a frame. Normally, these are the three aspects which one would look at: the textual, the contextual, and the historical. We have, and the solicitor read it out to your Lordship. The author of the provision and the list of dates given by the solicitor sets out in detail the confabulations, including differences of opinion on whether there should at all be a special treatment of Kashmir. Then, my Lord, Gopal Swami Iyengar's draft, its brief discussion, and its adoption by the Constituent Assembly. And one thing was clear: this was an element accommodating certain compromises, political compromises within the constitutional framework. Your Lordship has read all of that. I'm not going to repeat reading any of that. But that has been sufficiently put across. And it now stands as it does, and its words have to be given their plain meaning. So, my Lord, the first thing Your Lordship would do in my respectful submission is the textual bit. Now, in the textual bit, what is of great significance in this point has been put. If the idea was that the President could act only to give effect to a recommendation of the Constituent Assembly, then that would have been made the precondition for exercise of power. Perhaps the article would have said, if a recommendation is received from the Constituent Assembly, then the President may. And Your Lord, in fact, in the course of the hearing, my Lord, the Chief Justice gave the example of certain other articles where it says, if a reference is made or if something is done, then. But that's not the frame in which this was drawn up. One of the articles, my Lord, of that kind is 249. Vocats are very well familiar with that. It starts by saying, if the Council of States has declared by resolution, then it shall be lawful to make laws. So that is a precondition for the exercise of power.
But Mr. Salve,
Yes.
does the proviso to Article 370(3) does not bring about the same result
Yes.
by the use of the expression shall be necessary?
Yes. So, my Lord, shall be necessary here must then be subject to the principle that if there is a Constituent Assembly, then it's first of all, the word is recommendation, not concurrence. And secondly, that becomes necessary because if there is a Constituent Assembly, then you cannot act in vacuo. That was, in my respectful submission, the textually, because my Lord, we must first of all discern legislative intent out of language. And from the language, when the Constitution knows, or the drafting of the Constitution, the authors of the Constitution knew that there were certain models in which it says, if something is done, then you may exercise a power. Is the President to act, my Lord, only to give effect to the desire of the Constituent Assembly, or is he to receive a recommendation from the Constituent Assembly? And obviously, the compromise was he must receive a recommendation from the Constituent Assembly, which obviously means if there is one, he must. Secondly, my Lord, this very article, and we have all this is textual. This very article uses two separate expressions. B2 uses the word concurrence. I mean, it's a point which has been already made. And the proviso uses recommendation. Now, if Malad 1 had put concurrence here, the argument would still remain, but it would have been a much stronger place for the Constituent Assembly. So while Malad, distribution of the fields of legislation in subarticle B of in clause B of subarticle 1 was put as concurrence of the government of the state. At the same time, subarticle 3 used the word recommendation. It's not an amendment, it's not this. So one must assume, and this was a article which had internal dissensions and differences, and it was very carefully crafted between the within the committee and within the assembly. There were differing points of view. So my lord, we must give meaning to every word of this article. So the difference between concurrence and recommendation and its framing as a proviso. At two places, again, subarticle 2 says if the concurrence. So, my lord, this is a very conscious departure from the concurrence, recommendation, consultation, recommendation, concurrence. One would perhaps say the difference is if you fail to consult, it is not fatal. If you fail to obtain a recommendation, if a recommendation is necessary, it is of more serious consequence. Would it be fatal? I don't know. Concurrence, obviously, because concurrence, then your power gets hedged in. And this is all textual.
So, Mr. Sarve, there's one countervailing consideration
Yes,
which we
yes.
possibly may have to bear in mind,
Yes.
that where a change in the distribution of legislative power was envisaged,
Yes.
the provisions spoke of concurrence,
Yes.
except in the area which was covered by the instrument of accession.
Yes, madam.
The exercise of the power under the proviso to clause 3 brings about a complete abrogation of status.
Correct, madam.
Abrogation of 370.
Yes.
In which case, all the limitations which are even introduced by the earlier provisions of clause of Article 370 are lifted.
Yes.
Including the concurrence on the distribution of legislative power,
Yes.
consultation.
Yes.
Now, could it have been the intent that you require the concurrence for altering the distribution of legislative power or for altering any other provision of the Constitution, but for abrogating the article itself, nothing more than a mere recommendation is required?
Which, my lord, drops me, I'm deeply obliged, my lord, which brings me to the second, the contextual.
Power under the proviso is exercised,
Yes.
then there is no limitation at all.
Absolutely. And that, my lord, brings me to B, the contextual. And in fact, that was the direct intent. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the constitution sets out legislative powers in the 7th schedule in absolute terms. And you need a very elaborate mechanism to tinker with those 7th schedule. It has to be with 50% states voting, etc. Your lordship knows the difference. Here, there was a political agreement and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant. The problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370, the purpose of 370 was not to create a permanent divide in the constitution. And there are lots of material has been shown to your lordship on this. It was a phased integration. I'm going to deal, Manoj. Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, Manoj, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3 that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. If one looks at it that way, the whole thing falls in place. We kept, the framers of the Constitution kept with the President the power to do away with this special arrangement.
Yes.
And history will not bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because, my lord, the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms, the history of Kashmir did give rise to apprehensions. And the lordship has seen all the material. So, border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in sub-article 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were 2 approaches. One was the jackboot, saying doesn't matter, things will settle down, don't agree to anything special for Kashmir. The other was the other extreme, saying if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions. And such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, my lord, I'll give your lordship that passage. Justice Pandian, I think Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas. I'll give your lordship the exact passage. The fact that the ground realities would change in Jammu and Kashmir and 370 would accommodate was not first recognized by your lordship in the Makbul Damnu case, which has been cited. The challenge brought where Mr. Garg argued that without the Sadr Riyasat, you could not have the preventive detention law. And your lordship said state means state as exists from time to time. That is, my lord, already there. I'll give your lordship the passage 72-1 Supreme Court cases 536.
You have given us para 28.
It's there, my lord. It's volume 1 CLC
And
PDF.
you said para
36.
28 there.
Para 28. So this was already one example of how this evolved. And that, my lord, backs in with a principle of construction. Your lord, the attorney just cited the presidential reference case, which says, well, if there is a requirement, then if there is a constituent assembly, you must get the recommendation. But if there is no constituent assembly, are you denuded of the power? And the presidential reference, my lord, the attorney just gave your lordships a moment ago. The judgment based on a passage on impossibility. And your lordship cited with approval Craze on Legislation, the 6th edition, in the presidential reference. The attorney just gave it, madam. The
Yes.
attorney just cited it. I have, my lord, for your lordship's assistance, given the 9th edition of Craze. I believe it's attached to my submissions. There's some slight interesting change in the text. I believe it is at PDF page 37.
Mr. Salve, which is your compilation of it?
Well, I believe it has been given along with my note.
Is it along with the note itself?
Yes. This is not from the 9th edition of Craze. It's called Disregarding the Impossible. Para 8.2.9. It is appended to the note.
What page did you say, Mr. Zari?
Page 37 PDF.
Yes. Disregarding the impossible.
Yes. Yes. There's a slight difference in text from what your lordships approved, and in fact, it's even more instructive. It says one of the ancient maxims of common law is lex non causa ad impossibilia. As Broom's legal maxim puts it, the maxim, or as it is expressed, impotentia excusat legem, must be understood in the qualified sense that impotentia excuses, where there is a necessary or invincible disability to perform the mandatory part of law or forbear. It is akin to the maxim of the Roman law, nemo tenetur ad impossibilia, which, derived from common sense and natural equity, has been adopted and applied by the law of England under various and dissimilar circumstances. The result of the application of the maxim, which remains potent, is that the draftsman need not expressly excuse that compliance, which is obviously impossible. So, for example, if requiring a particular communication to take the prescribed form, the draftsman need not generally state that the requirement can be lawfully ignored where no form has been prescribed for that purpose. There may be occasions, however, where the sense of the legislation makes it arguable that the primary provisions are not to operate at all until certain mechanisms have been put to place by subordinate legislation. If the draftsman thinks it is necessary to avoid a suggestion of that kind, he will generally qualify a reference to the prescription by, if any, of that kind. So, Malad, the principle is very interesting. In fact, we have used it in a different branch, Malad. In service law, for example, we've used it all the time. It says your promotion will be as per rules. Now, if no rules are framed, doesn't mean you won't get a promotion. Then you follow whatever is the general principle. But if there are rules, they must be strictly followed. Oh, Malad, this was the argument in this court. Of course, I went through the judgment. It didn't get to that point of deciding it. The old Malad section 80J rule 19(1)J, and the argument was, for example, if it says deduction of capital employed, if there are rules, you follow them. If there are no rules, doesn't mean the exemption fails. But there are other provisions which says you will get such other deductions as rules may provide. And that you can't operate unless there are rules. So we have had Malad these two formats. And that is why we come back to why did the framers of the Constitution not say that if the president receives a recommendation from the Constituent Assembly, then he may. And instead say the president may abrogate this article, provided if he gets a recommendation from the Constituent Assembly. Which there is one, you must get the recommendation, otherwise. Now, Malad, this was also made.
Just 1 minute.
I'm sorry.
Mr. Salve? I think perhaps we'll just wait for a second, Mr. Yes, Mr. Salve. Mr. Salve? Voice is perhaps, for a moment he was...
Now, my lord.
Yes, Mr. Salve.
Yes. Can your lordship hear me, my lord?
Yes, we can hear you now.
Yes. Finally, my lord, look at one important nuance of this article.
Yes.
In subclause D of clause B, such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the present by order specifies. So, power to the president to apply or disapply provisions of the constitution or apply them with modifications. And this does not require unlike B1, that is the spread in the list, the concurrence is not called for.
Let's look at it now, Mr. Salve. Let's see that again. I don't...
Yes. If your lordship sees 372(1)(b), 1 is the spread, my lord, of the list. Small subclauses 1 and 2.
Corresponding to the IOA.
Yes.
That requires consultation.
That requires concurrence. That comes in through the first proviso.
B.
Proviso, no such order which relates to...
requires concurrence.
Yeah, B1 requires concurrence, consultation.
No, consultation.
Correct, my lord? And no such order which relates to matter other than those referred to shall be in the concurrence of the government. So this was built in. This dichotomy was built in there itself. Now, two things, my lord, your lordship will note. Applying or disapplying provisions of the constitution.
No, Mr. Salve, I could not get this argument.
Yeah, yes. may I just restate the point, ma'am? Clause D relates to not 370, but other provisions of the Constitution.
Absolutely.
And they can be applied, disapplied, or with such modifications as the president considers appropriate. And that is with the concurrence of that government.
Yes.
Correct, madam? And sub-article 2 says, is the concurrence referred to in paragraph 2 of B of clause 1, such other matters, or in the second proviso, that is, my lord, would be D, be given before the Constituent Assembly for framing of the Constitution, it will be placed before the Assembly for such decision as it may take thereon. So this was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Sarve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe.
I'll repeat it, Madam.
Yeah, if you could.
Disapplying 370 itself comes under sub-article 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work, to try and find this area of accommodating both.
That's
So if
fair enough. Mr. Sarve, we got your point.
Yeah,
That
that's
after all, this is a proviso.
Yes.
It uses the word recommendation and it does not
Yes.
say if there is a recommendation. We got that
Yes.
point. We got that line of argument.
I was just closing it by saying,
You're making just a little while ago
yes,
was that you began by saying that B1
yes,
requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
yes,
D says, subject to such exceptions and modifications as the President may order by order specify.
yes,
There also there is a bifurcation.
yes,
Matters which refer to the instrument of accession require consultation. Other matters other than those governed by the instrument of accession require concurrence.
correct. Now, the point which I was making, perhaps
that's
that
the
got
point
lost.
which we wanted you to just come back
Yes.
to again. Yes.
So again, my lord, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
Where do you say that? How do you say that?
Because, my lord, instrument of accession requires consultation, not concurrence. The first proviso.
Subjects are so important. Convenience.
Why this dichotomy in the first and second proviso, my lord? Your lordship would have to reflect over. And that also, Malad, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
You know, Mr. Salve,
Yes.
clause B of 370, 371B
Yes.
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the president, the power of parliament to make laws would be limited by specific matters.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of parliament to make the law. There's no power to make exceptions or modifications in clause B at all.
No.
And
Not at all.
bifurcate, you correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because
Yes.
these matters clearly specified in the IOA: defense,
Correct.
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation with the state government was required,
Yes.
because they were specified in black and white in the IOA.
Correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and Malad,
Now, when it comes to
yes.
D, D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And Malad, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363. That these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in sub-article. That if you want to completely disapply this political arrangement, if there is a constituent assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same is on the same
Philosophy.
trend, or is the same platform
Yes.
as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, Malad.
Power
The
under
underpinning is the same.
the first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president, instead of driving one to Article 368, reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive president is executive government, where the executive government can disapply a provision of the constitution.
The only internal problem with that argument, Mr. Salve, we'll reflect on
Yes.
it during the recess in the
Yes.
next hour,
Yes.
that where the power to do something lesser in terms of constitutional impact is hedged in with restrictions, namely the power to make exceptions and modifications. Can we subsume that the power to have something greater, which has
Yes.
greater constitutional impact, namely the abrogation itself, will be bereft of all limitations?
My lord, to which my respectful response is, there is a compromise. I keep in my control, because the accession is complete. Let's, so what are the understanding? It's a part of India. 1 and 3 apply. It's an Indian state. But I have a political compromise in which sub-article 1 has how it will operate. That's the compromise. But sub-article 3 is to put the compromise to an end. And I reserve that power.
Mrs. Harvey, we are almost at the anvil of lunch. Just
Yes.
one, maybe one of the juniors can do it here in the court as well.
Yes.
Found which were those matters governed by B1 and which were the matters governed by B2. B1 basically covered the 3 subjects.
Yes.
Now, which were the matters in the IOA to which the first proviso to D applies?
We'll not try and respond to that at 2 p.m.
So we'll,
I see that. I see that.
that will give us some insight on what was the intent
Yes,
of
yes, yes. Yes, yes. I'm deeply obliged. We'll do that.
So many articles that deal with defense, which are covered by the instrument of accession.
Well,
And that list is given.
Well, I had in my list of dates, Lordships would recall the sub-article A1 says that the president would demarcate which entries fall within those 3 areas. First order,
48 or 54.
yes, my lord, which 50, my lord,
50, 50, 50.
which
54
because
then.
communication would have telecommunication, postal communication, etc., etc. So 3
So
entries.
which were the other articles?
No, we'll respond to that at 2.
Because D, the first proviso to D for Delhi, deals with other articles, not the specification of matters in the list. Not D1, the first proviso to clause D deals with other matters which are governed by the instrument of accession, where again consultation only is required. We're just sort of understanding Mrs. Salve's
Communications is also in the list. That is also not other
No,
articles.
no, I don't think Mr. Sibal has understood. My lord, I followed your lordship's
Also in the
question.
list,
I'll respond to it too.
We'll also try.
That may have some bearing, Mr. Salve.
Yes, yes, of course, of course.
Your argument on clause 3, that's why. I
Yes,
asked.
my lord. Yes, I'll do it at 2. I'll do it
That's
at
a
2.
very interesting point. We'll also leave it here.
Yes, yes.
The list is all there. Which one is also in the list?